I would like to briefly keep counsel here just so that we can talk about scheduling for next week. So there are three things that I have on my list of things to do. Number one is whether the defense wants to make a motion for judgment of acquittal. Number two is the Curtis advisement. I at least would like to make the first part of that advisement for the defendant. And number three is having at least some discussion about the instructions. I understand that the defense may not be ready to take a final position on all instructions, but I think it would be very productive to start talking about instructions. Now, I don't need all of you here. If you don't all want to be here, I need to have the defendant here, and I need to have at least one attorney per side. So I'll leave it up to you. So we have to decide what day we come in. And I'm pretty open in terms of whether we do it on Monday, or we do it on Tuesday, or we do it on Wednesday. Do you have a preference, Ms. Nelson?
Your Honor, I discussed this briefly with Mr. Orman and Ms. Pearson this morning, and what I was thinking was perhaps it would be helpful if I could submit to the court on Tuesday, maybe by noon, some initial instructions, defense proposed instructions, and I can do that. I think Rule 30 requires me to submit those, actually file those with the clerk, and I can give you a disc or else email a Word version of those if that would be helpful.
That would be great. That would be very helpful, in fact. So I would appreciate you doing that. So if you can do that on Tuesday, perhaps we could meet on Wednesday?
That's what we were thinking, Your Honor, in the morning,
Okay.
perhaps. And then we will have some additional instructions, probably a theory of the case instruction and some other instructions when at the close of all of the evidence, but these will be, sort of the basic ones that we can get started with, and I think we're all available to do that, begin that discussion on Wednesday morning if that would work for the court.
That would work for me. To the extent that you're thinking along the lines of requesting lesser included offenses, and I'm not saying that you are or that you're not, but the more notice you can give me with respect to those, the better off we're going to be. And again, I'm not making any rulings at this time as to whether I think any lesser included offenses would be either requested or allowed by the court, but to the extent that that's something that you're going to be interested in, I think we should start talking about it sooner rather than later.
Understood, Your Honor.
All right. Mr. Orman.
Wednesday's fine with us, Your Honor, and we appreciate counsel's offer to get those jury instructions us the day before. Regarding the first issue that the court raised, the mid-trial motion, my preference would be to do that this afternoon. We still have some victims here. They might want to see that rather than us talk about jury instructions and a Curtis advisement and things of that nature. I'm ready for any defense motion for judgment of acquittal.
All right. Is that okay with you, Ms. Nelson? I'm assuming you're the one who's going to be making it.
That's fine, Your Honor. It will be very brief.
Okay. All right. Do you folks want to take a short break?
That's fine with us, Your Honor.
All right. Why don't we take like a 15-minute break and then we'll proceed. Okay. The court will be in recess. Thank you. Records should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. All right. Ms. Nelson?
Your Honor, at this time the defense moves for a judgment of acquittal on all counts charged in the complaint. The defense submits that the evidence, when viewed as a whole in the light most favorable to the prosecution, is not substantial and sufficient to support a conclusion by a reasonable jury that Mr. Holmes formed the requisite mental state for each of the charged offenses. With respect to the counts alleging after deliberation and with intent, counts 1 through 12, 25 through 82, 143, 145, 147, 149.
Hold on. Let me keep up with you.
It's okay. It's just all the intentional counts, but
Okay.
149, 151, 153, 155, 157, 159, 161, 163, and 165. The defense submits that the evidence, when viewed as a whole in the light most favorable to the prosecution, is not sufficient to support a conclusion by a reasonable jury that Mr. Holmes possessed the specific intent to cause the death of any particular victim. Other than that, Your Honor, we stand on the record and cite to Mr. Holmes' state and federal constitutional right to due process pursuant to the Fifth Amendment, 14th Amendment, and Colorado Constitution, Article 2, Section 25. In addition, because this is a case in which the prosecution is seeking the death penalty, the defense maintains that a heightened standard of reliability applies to this in all stages of the proceedings. We cite to Beck versus Alabama, as well as the Eighth Amendment and Colorado Constitution, Article 2, Section 20. And that's all the argument that I have.
All right, thank you. Mr. Orman?
Your Honor, regarding the culpable mental state for, well, I guess this can be divided into a few different groups of charges. There's the, start with the charge at the apartment, the incendiary explosive device. I think that people have presented ample evidence that the defendant formed the requisite culpable mental state for that offense. He put all that together. The court saw that he did research on how to make bombs. There's additional screen captures that show, that I did not publish but are in evidence, that show that he was looking on numerous searches how to make pipe bombs, various combinations of incendiary materials, and I don't think any further discussion of that is warranted unless the court has questions on that.
The culpable mental state element of that offense is knowingly, correct?
That is correct, Your Honor. Regarding there's then other types of charges in this case. We have, for the 12 deceased victims, we have 2 counts of murder each, one under after deliberation with intent and the other under the extreme indifference theory. Same for all of the victims of the various counts of attempted murder charged under both theories. I will spend most of my time, and I'm going to try to be brief, but I want to be also, I just want to get out what I need to say here. For the charges of attempted murder after deliberation and first-degree murder after deliberation, I think the court can look at all of the facts and show that we have shown overwhelming evidence of the requisite culpable mental state of after deliberation with intent. In fact, I doubt there's ever been a case presented in the state of Colorado that has had more evidence of deliberation and intent than we have presented in this case. And frankly, I doubt there's been many in the United States.
I think there was an argument that there's not sufficient evidence that the defendant possessed the specific intent to cause the death of any particular person.
Well, yeah, I heard that argument, Your Honor, and I will address that. Look at the weaponry that he acquired. Serious machinery of death and mayhem. And when I say mayhem, I mean that in the sense that Blackstone, the Commonwealth sense, not the colloquial sense of the word mayhem. And he, in fact, did cause mayhem in the common law sense, as Blackstone would have known it. He had a tactical pump-action shotgun that he went in that theater loaded with 6 rounds. Each of those rounds containing, as Dale Higashi said, 100 pellets. A semi-automatic assault rifle with a 100-round drum magazine. I submit to the court that that shows he went in there with the intent to kill everyone in the theater. We have a handgun with, I think the evidence shows, probably had 16 rounds in it. In the theater were found 65 spent .223 casings, 6 spent shotgun shells that contain at least, or contain 100 pellets apiece, 5 spent .40 caliber casings, 218 live .223 rounds, and 16 live .40 caliber rounds. Outside the theater, the rifle had 31 rounds in it. The Glock on the roof of his car had 16 rounds in it. So he went into the theater with at least 314 .223 rounds. And but for the malfunctioning of the drum magazine and the other facts and circumstances, he would have killed a lot more people. We have the ammunition outside the theater, Your Honor. There were 13 .40 caliber magazines with a total of 240 rounds. There was a .223 magazine with 31 rounds in it. Plus there were 2 .223 magazines in the car. Now they didn't count the bullets in those, but they appeared to be full 30-round magazines. And 2 stray .223 rounds in the car. And in the car were 6 buckshot shotgun shells with 8 pellets each. So adding up what was in the theater and what was found outside, the defendant drove to the theater with more than 400 .223 rounds. I think 407 is the exact count. More than 275 .40 caliber rounds. I think 277 is the exact count. And 12 shotgun shells. In other words, and each of those had 100 pellets in it. But even without counting those as 100 pellets each, he went to the theater with close to 700 rounds of ammunition and 4 guns. I think it's also important to note the testimony of Dale Higashi that the .223 rounds were steel penetrator rounds. These rounds, Your Honor, went through the theater seats and the wall to Theater 8 as a hot knife goes through butter. We have testimony of witnesses that show the defendant aiming into the places in that theater where people were located. We have testimony of victims indicating that as they were fleeing, the defendant shot at them. We heard from Ashley Mosier today that as she stood up, she was shot. We had testimony that this is a semi-automatic .223 and that the shotgun required a pump action between each shot and that the handgun required an individual pull of the trigger to fire each bullet. Every time the defendant pulled the trigger of any of those guns, his intent, and I don't even think I need to talk about deliberation, it was so much evidence of that. His intent was to kill whatever person, and he saw particular people and aimed at particular people, was in the path of that bullet. So he went into the theater with malice aforethought, with long and extensive planning. He had bought targets. He had gone to a shooting range. He searched for shooting ranges on the internet. He went to that theater, stepped out feigning a phone call, and his car was parked right outside. He came back into the theater, and the evidence shows that what his intent was to make a corpse of every living soul in that theater. That's what he went in there to do. That he did it with 12 people, and he tried to do it with everybody else. I could see, and I appreciate counsel not belaboring this in her argument, I could see an argument for a differentiation between the people in Theater 8 and Theater 9, and I imagine Your Honor would ask me about that. So unless Your Honor doesn't want me to argue that, I have some thoughts on that.
Go ahead.
I think it's important for the Theater 8 victims to remember the testimony about the steel penetrator rounds and the visual evidence that Your Honor saw about how those rounds went through that wall and people got shot in that other room. The defendant picked a round of ammunition that would do that, pulled the trigger on that gun over 60 times. He intended to kill what was ever in the path of those bullets. So I think if you look at the statute on criminal attempt, he had the requisite culpable mental state, and he took a substantial step towards killing people in Theater 8. And we charged 3 of them as victims. We could have charged everyone in there as a victim of attempted murder. We could have charged everyone in Theater 9 as a victim of attempted murder because the defendant went in there to kill all of them. That was his intent, and he took a substantial step towards doing that. We limited our charging because, frankly, we knew that the evidence in this case would be voluminous, and we knew how long a trial would take. We called every victim charged as a victim of attempted murder, or listed in one of those charges, and imagine how much longer this trial would have taken with 400 people or so charged. The other, I guess, theory that we could proceed under on Theater 8, and this is a little bit more esoteric, in addition to what I said, and I think that establishes enough evidence for the charges in Theater 8.
Well, before you move on from Theater 8,
Yeah.
my understanding of Colorado law is that you don't have to prove that the defendant intended to kill one of the specific victims who was killed, that the proof that's required is that the defendant intended to kill a person and then ended up killing someone, whether it's that person or someone else. Is that right?
That is absolutely correct, Your Honor. That is drafted into the statute for first-degree murder. And you require to intend to kill a person and another person, or that person gets killed. It doesn't matter who, or multiple people get killed.
So in terms of Theater 8, there doesn't have to be intent to kill anyone in Theater 8 as long as you prove beyond a reasonable doubt that after deliberation he had the intent to kill someone in Theater 9 and then someone in Theater 8, let's say, was killed. Then your position is you could still charge first-degree murder after deliberation and with intent with respect to that victim in Theater 8.
I have two theories on that, Your Honor. That is one of them. That's the one I was actually about to get to. The first one is he intended to kill whoever was in the path of that bullet, and he knew people would be there. He picked crowded places where he knew people would be. And that, we don't even need the transferred intent argument. But I would say also, Your Honor, yes. I mean, under the statute, I think Colorado has adopted, per se, what the common law would have called transferred intent in a homicide case. And I think Colorado has actually expanded it and made it more certain as to what is meant by that. A lot of states still have common law murder, and they just have courts deciding about transferred intent. But Colorado has made it clear, and I think if you look at the statutes, this fits. The Theater 8 people fit within what the statute says. But even if we were just going under common law transferred intent, I could not find a specific Colorado case applying the concept of transferred intent to attempted first-degree murder after deliberation. And I looked. I did look in other states, and I can, if the court is interested in what other states have said on this point, I can provide some citations to the court. If the court doesn't need that, I don't want to waste the court's time.
You can give me a summary if you want.
Your Honor, there's a number of states. I'll just cite to a case from Oklahoma. Short versus State, 980 Pacific 2nd, 1081, which is from the Oklahoma Court of Criminal Appeals in 1999. And it's sort of a similar situation to this, although not as many victims. It's a very long case, Your Honor, specifically pages 1097 to 1099, long discussion, finding that transferred intent applies to attempted murder. Also in favor of that concept would be People versus Ephraim, EPHRAIM, from the Illinois Intermediate Appellate Court in 2011. The citation there is 753 Northeast 486, with a long discussion on page 496. Also supportive of this concept, Your Honor, would be People versus Backdash, BACKDASH, which is at 890 Northwest 2nd, 906, Minnesota Intermediate Court of Appeals. And I'm not exactly sure what that's called, but it's Minnesota App 2013. So it is, I think, a recognized concept of transferred intent, even in attempted murder after deliberation. So I think the people have shown sufficient evidence to submit this case to the jury on each and every count charge, and unless Your Honor has any questions for me, I'm done talking.
Just going back to your other theory, not the transferred intent theory, but the one that says he intended to kill anyone in the path of the bullet, your position would be that with respect to the folks in Theater 8, that he shot at the wall in Theater 9, knowing the power of the bullets, and his intent was to kill anyone in the path of that bullet or those bullets that went through the wall that divided Theater 8 from Theater 9.
That's right. That's right.
All right. Anything else?
Just one thing, Your Honor. I would cite to the court a Colorado case that says we can proceed under both theories of extreme indifference and after deliberation, and we don't have to, and there's nothing impermissible about submitting both of those to the jury and having them reach verdicts on both of those. And they are not mutually exclusive or contrary. And that would be Candelaria versus the People. And that's Candelaria, 148 Pacific 3rd, 178 from the Colorado Supreme Court, 2006.
I believe that's an opinion by Justice Coates, right?
Your Honor, you got that on me. I don't remember what justice wrote that.
It is, Your Honor.
All right, thank you, Ms. Nelson. In terms of the extreme indifference count, your position is that the mental state element required, or the culpable mental state element required, is knowingly, and that there is sufficient evidence here with respect to the deceased victims in Theater 9 as well as the surviving victims in Theater 9 and Theater 8.
Yes, Your Honor.
All right. And by the way, I know that there are no deceased victims in Theater 8. My discussion earlier with Mr. Orman was just for purposes of understanding his position. So, all right. Anything else, Mr. Orman?
Not unless you have any questions for me, Your Honor.
I do not.
Thank you.
Thank you. All right. The case that set the standard governing motions for judgment of acquittal is People versus Bennett, B-E-N-N-E-T-T. That's a Colorado Supreme Court case from 1973, and it's published at 183 Colorado 125, 515 Pacific 2nd, 466. In that case, the court said that when a trial judge is confronted with a motion for a judgment of acquittal at either the close of the prosecution's case or the close of all the evidence, he must determine whether the evidence before the jury is sufficient in both quantity and quality to submit the issue of the defendant's guilt or innocence to the jury. To withstand the motion for a judgment of acquittal, the prosecution has the burden of establishing a prima facie case of guilt and must introduce sufficient evidence to establish guilt beyond a reasonable doubt, no more, no less. In passing upon a motion for judgment of acquittal, the trial judge should not attempt to serve as a 13th juror or to invade the province of the jury, but should prevent a case from being submitted to the jury when the prosecution has failed to meet its burden of proof. The issue before the trial judge is whether the relevant evidence, both direct and circumstantial, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. And I'm reading from different portions of the opinion in Bennett. Finally, the Bennett court said that in passing on the motion for a judgment of acquittal, the trial judge is required to give full consideration to the right of the jury to determine the credibility of witnesses, the weight to be afforded the evidence, as well as the right to draw all justifiable inferences of fact from the evidence. When viewing the evidence in that light, the trial judge must determine whether a reasonable mind would conclude that the defendant's guilt as to each material element of the offense was proven beyond a reasonable doubt. If the evidence is such that reasonable jurors must necessarily have a reasonable doubt, the judge must direct an acquittal because no other result is permissible within the scope of the jury's function. So in this case, given the relevant evidence, both direct and circumstantial, when I view it as a whole and in the light most favorable to the prosecution, which I'm required to do at this juncture in the proceedings, I find that it is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of all the charges beyond a reasonable doubt. I agree with Mr. Orman that the culpable mental state element required by all the counts related to the deceased victims that have charged the defendant with first-degree murder after deliberation and with intent is after deliberation and with intent. That's the culpable mental state. And but it doesn't relate to any particular victim. In other words, the prosecution doesn't have to prove that the defendant, after deliberation, intended to kill a particular victim in that theater. For example, let's say that John Doe was at the theater among hundreds of people. The prosecution doesn't have to prove that he intended to kill John Doe. the prosecution has to prove beyond a reasonable doubt that after deliberation, the defendant intended to kill a person, and that the defendant then killed a person. So in this case, the evidence is both substantial and sufficient, at least when viewed in the light most favorable to the people, to support a conclusion that the defendant, after deliberation, intended to kill a person, and that he caused the death of the particular victims who are listed in all the charges that deal with first-degree murder after deliberation and with intent. In terms of the charges that deal with attempt to commit first-degree murder after deliberation and with intent, the prosecution has proven, the prosecution has presented sufficient and substantial evidence, at least when viewed in the light most favorable to the prosecution, that the defendant acted after deliberation and with intent, and that he took a substantial step toward causing the death of a person, the person listed in each of the attempted murder, first-degree murder charges. So there is substantial and sufficient evidence when viewed in the light most favorable to the people that the defendant engaged in conduct that constituted a substantial step toward the commission of the crime of first-degree murder with respect to all the attempted murder after deliberation and with intent counts. In terms of the extreme indifference first-degree murder counts, the culpable mental state element required is knowingly. And again, I find that when viewed in the light most favorable to the people, there is substantial and sufficient evidence to support a conclusion by a reasonable mind that the defendant acted knowingly in terms of all those counts. And I'm focusing on the culpable mental state elements because that's what the defense focused on in its argument. But I am finding that the relevant evidence, both direct and circumstantial, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charges of first-degree murder, extreme indifference. The same thing is true for all the charges related to criminal attempt to commit first-degree murder, extreme indifference, all those counts. And then finally, we have the one count of possession of incendiary devices. And the culpable mental state element required there is knowingly. I agree with Mr. Orman that when the evidence, both direct and circumstantial, is viewed as a whole and in the light most favorable to the prosecution, it is substantial and sufficient to support a conclusion by a reasonable mind that the defendant acted knowingly in possessing the incendiary devices recovered from his apartment and that he is guilty of that charge. And so at this time, the motion for judgment of acquittal is denied. Is there any other record that the people want me to make?
No, Your Honor, thank you.
Is there any other record that the defense wants me to make?
No, Your Honor.
Okay. How about if we meet at 9 o'clock on Monday? Or do you want,
Wednesday.
or excuse me, Wednesday, or do you want to do something later than 9?
I think 9 o'clock is good with us. There's one other matter I think I should just raise with the court.
Hold on, let me just make sure 9 is okay with Ms. Nelson.
9 is fine, Your Honor. We can do earlier too if you want, but 9 is fine.
All right, let's do 9.
I got in my email that I think the Denver Post, I'm not sure if it was other companies, had filed a motion with the court today regarding access to the admitted exhibits. And I don't know what the court is going to want, if anything, from the parties, but I don't know if you want to discuss that Wednesday when we're here.
That was my next note. Mr. Zandsberg apparently filed a motion. So how much time do the parties need to respond to Mr. Zandsberg's motion? I was thinking 6 weeks.
That would be sufficient, Your Honor.
That works for me too.
All right, that's what we'll do. Parties are busy, so is the court. All right, anything else on behalf of the people?
Thank you, Judge. Real quickly, I have 3 court trial exhibits. CTR 73, this is the, from yesterday, the hot mail that was pulled out And then CTR 74, these are the additional 4 pages from the bench conference this morning, so I've marked all of those. And then People's Exhibit 347, which was the DVD from Microsoft, was never introduced into evidence. I've marked that as CTR 75.
Okay, thank you. Ms. Spengler?
Thank you, Judge. I have one brief matter.
Yes.
Months ago, before we knew we'd have a break on June 22nd, this coming Monday, we had issued a subpoena, served a subpoena for a lay witness. So I expect that if they appear on the subpoena to return on Monday morning at 8:15, and I was hoping that the court or a court would be available to continue the subpoena until later in the week.
As long as there's somebody from your office available.
I'll be here.
Will you be here?
Mm-hmm.
And somebody from the DA's office available? You want to be here? All right. I'll make arrangements and I'll communicate through my staff with both of you as to what courtroom, okay?
Okay.
All right.
Thank you.
Thank you for letting me know. All right, anything else? No? Okay, I'll see you, some of you I'll see on Wednesday and the rest on Thursday. All right, the court will be in recess. Thanks, everyone.